Honorable the President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Announcements by the President. Petitions, papers.
Acting Leader of Government Business.
Thank you very much, Madam President. It's nice to be back. Madam President, I have the honor to lay the following paper as listed on the supplemental order paper in the name of the Minister of Rural Development and Local Government. The ministerial response of the Ministry of Rural Development and Local Government to the 6th report of the Joint Select Committee on Land and Physical Infrastructure on an inquiry into the establishment of systems for the maintenance of drainage and roadways.
Reports from...
One, yes.
Madam President, I have the honor to lay the following paper as listed on the supplemental order paper in the name of the Attorney General. The Immigration Amendment Regulations 2019.
Reports from committees. Urgent questions.
Senator Mark.
Thank you, Madam. To the Minister of Labor and Small Enterprise Development. In light of the explosion of an oil tanker in the mining fields operated by Massey Energy Production Resources Limited, which led to the death of one person and injuries to another, can the Minister indicate whether this matter will be independently investigated?
Minister of Labor and Small Enterprise Development.
Thank you. Thank you very much, Madam President, and I thank my honorable colleague for posing this question. Madam President, the Occupational Safety and Health Agency is empowered under the Occupational Safety and Health Act, Chapter 8808, to, among other things, investigate workplace accidents, including work-related fatalities. Madam President, the unfortunate accident which occurred recently and tragically took the life of a worker, we on the government bench wishes to extend our deepest condolences to the family and pray that God will be with them during this very difficult time in their lives. Madam President, I am informed that OSHA was notified of an accident that occurred on June 4th at approximately 10:20 a.m. at Massey Energy, Maruga West Oil Field, Haggard Trace, Rock Road, Pinal, which resulted in fatal injury to Mr. Philip Ramlochan of Light Pole 92 Harris Village, South Oropouche, a driver, floorman, and also critical injury to Mr. De Paul Suku of number 1 Mount Jacob Road, Hassan Ali Trace, North Lower Barrackpore, a headman, both employed with Total Contractors Services Limited. Madam President, the Occupational Safety and Health Authority initiated an investigation on Tuesday, the 4th of June.
Minister, your time is up. Senator Mark.
Okay. Madam President, through you, can I ask the Honorable Minister what period of time this investigation will be executed by the Occupational Health Authority? What period of time it will take for this report to be completed?
Minister.
Madam President, I am not in a position to give the Honorable Senator the information he seeks, but I can give him the comfort that this investigation will be conducted with the highest priority.
Madam President, can I ask through you to the Honorable Minister whether she is aware of any counseling services being offered by the employers as it relates to the family and the affected workers, you know, who would have witnessed this tragedy? Can you share with this House?
Minister.
Madam President, while I do not have that precise information, I would certainly hope that the employer would offer such counseling services to the family of not only the worker who died, but the one who is injured also.
Questions on notice. Questions for oral answer.
Leader of Government Business.
Madam President, I am pleased to announce that the government will be answering all questions on the order.
Senator Mark.
Thank you, Madam. Question number 155 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, this question, among many others, is based on a false premise. CITGO is currently not a supplier, nor is it a potential supplier of refined products for Trinidad and Tobago.
Senator Mark.
Madam President, may I ask the Honorable Minister whether he's aware that on the 13th of October 2018, a ship named High Mars collected refined products from Charles Lake in Louisiana, bound for Port of Spain. And that ship arrived at the Pointe-à-Pierre jetty on October the 23rd. Is the minister aware of such a shipment of refined products from Charles Lake, Louisiana?
Senator Mark, that question does not arise. Next question.
Can I further ask the minister whether he's aware that CITGO was able to supply refined products which was loaded on a vessel called High Mars that brought those refined products to Trinidad and Tobago on October last year, or in the month of October last year? Since the minister, Madam President, has denied that there's any relationship between CITGO and the government and the particular company that brings in refined products. Can the minister clarify this for us?
And Senator Mark, that question also does not arise.
Well, is the minister, Madam President, I'm giving him an opportunity to indicate for the records of this House, is the minister categorically indicating to this House that there is no relationship whatsoever between CITGO and Paria Fuel that is responsible for importing refined products for Trinidad and Tobago. Can the minister indicate categorically for the record that there's no such relationship? Can I ask through you for the minister to put on the record?
Senator Mark, that question I will not allow. And you have one more if you wish, or you want to move on to the next question?
Well, Madam President, I will move a motion. I'm not on a motion for the adjournment on this matter. Can I go on now to the next question?
Yes, you can.
Question number 156 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, a competitive request for proposal was issued by Pariah Fuel Trading Company in 2018 for the supply of fuels, and BP won on the basis of superior commercial terms and reliability of supply. The agreement was for the supply of products that met the Trinidad and Tobago Bureau of Standards over a 4-month period. In the global market, Madam President, a premium is applied to the world market reference price for variance in quality and transportation. This premium is typically 3 to 5% over the reference market price. It is therefore simply not true, as erroneously stated in the question, that this country is paying 1/3 more than the world market price for the importation of refined petroleum products. This is dangerous misinformation, as was the first question. Further, at present, Pariah does not have a current contract for supply of products with BP. The last cargo from BP's contract was delivered on February 13th, 2019.
Senator Mark.
Can I ask through you to the Honorable Minister, what was the then price paid by Pariah Trading Fuel or Pariah Fuel Trading for the importation of refined products supplied by BP on the date announced a short while ago by the Honorable Minister of Energy?
Minister.
Madam President, as stated before, in response to similar questions of this nature, Pariah went out for competitive tender for the supply of fuel, largely from traders. But that's where the business is. So BP may be exploration and production and refining, but they also have a trading arm. When you bid as a trader, you offer competitive prices. You may discount the reference price. Your markup may be 2%, whereas your competition may be 5%. If you win, you cannot disclose that price because you're jeopardizing the free market system. And no matter how much we try to put that into the heads of the UNC and the opposition, they're not listening. I don't know how to say it again, Madam President, but these are the facts. This is a commercial world. This is trading in international commodity. Why do you think you go for public tender? Why do you think you go for RFPs? It's because you're playing the market. And that's how the market operates, Senator Mark.
Senator Mark.
Yeah, Madam President, is the minister indicating that at this point in time and in the future, Pariah Trading will not be using BP supply and trade to import refined petroleum products for the people of Trinidad and Tobago? Can I ask the Honourable Minister?
Madam President, I never said that. I said BP won the first tender for the supply of a 4-month contract. Afterwards, it was retendered. Other companies and other traders won. And every time the 4-month or the 5-month or the 6-month period expires, they go back out for tender. So it is possible that BP could win again. I don't know. But it is a competitive environment.
Next question, Senator Mark.
Question number 157 to the Minister of Public Utilities.
Minister of Public Utilities.
Madam President, the International American Development Bank, the IDB, has been assisting the government of Trinidad and Tobago to address the challenges in the water and sanitation sector. In this regard, technical assistance was provided for an Israeli firm, Utilis, to visit the country to assist WASA in introducing cutting-edge technology involving the use of satellite imagery, achieving a reduction in the levels of non-revenue water caused by subsurface leaks in its water distribution system. Contrary to false assertions in this question, Utilis was engaged and paid for by the IDB. WASA has not entered into any agreement with Utilis nor made any payment to Utilis. Utilis visited the country from January 14th to the 18th, 2019, and conducted field exercises with WASA's management and water loss detection repair teams in the Northwest Trinidad and Tobago, Northwest Trinidad and in Tobago, as well as several on-site verification training activities in both islands. During the exercise, the following was achieved. A total of 127 points of interest were surveyed based on the imagery received, and a total of 98 leaks were found. Madam President, the average leak time taken to repair a leak varies depending on the nature of the complexity of the leak and can take from 1 day, where the mains are easily accessible, to as much as a week or more for more complex repairs. For example, in situations where the mains are required to be relocated, the lead time for such repairs would be much longer. That being said, the authority is doing everything within its power to have the number of leaks in the country, including in those identified by Utilis, repaired expeditiously.
Senator Ma.
Can I ask, through you to the Honourable Minister, whether this Israeli firm that conducted the technical work as outlined, whether the Minister intends to approach the IADB to have that firm revisit TNT to continue the work that it has started.
Minister.
Madam President, the short answer is no. We think that the technology, we found that the technology was helpful to some extent, but we were not very comfortable with the detection and how the preciseness of the information that was being given. And therefore, we have engaged in a number of other methods that we are going about to, with some degree of success in bringing the levels of leaks within the country down.
Senator Ma.
Can the Honourable Minister indicate whether we can have, or put it another way, Madam President, can the Minister make available the information regarding the arrangements between the IADB and this Israeli firm, which they would have paid for, but of course they came here to provide certain services? Is a public document available for public consumption? And if it is, can the Minister make same available to this Honourable Senate?
So you've just asked two questions there, if there's a document and can it be made if there is. Minister.
Madam President, there is no public document that is available per se. The IDB provided the assistance. They offered us to just come, and they had some new technology, some new companies, and they provided us the opportunity to come to look at this firm, try out their technology. They came, they conducted what they wanted. We were not happy with the particular imagery that we were getting. It was useful in helping us, and that was that. There is no documentation. I am not aware, and I'm not aware of the arrangement between IDB and the company themselves. That's a private document between both of them.
One more.
Through you, Honourable President, can the minister indicate whether Trinidad and Tobago was therefore used as an experiment by this Israeli firm testing its new technology? Was Trinidad and Tobago the first country that was used by this Israeli firm to really test its new technology? In other words, we were the guinea pigs. I'm trying to get clarification.
No, Senator Mark, I won't allow that question.
Public business, government business, bills, second reading.
Honourable members, the debate on the second reading of the following bill, which was in progress when the Senate adjourned on Tuesday, June the 4th, 2019, will be resumed. A bill entitled, An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011. When we adjourned on the last occasion, the Attorney General had just begun his winding up. Attorney General, you have 39 minutes of speaking time remaining.
Much obliged, Madam President. Madam President, that's 39 minutes in full time, yes? Much obliged, thank you. Madam President, I thank you for the opportunity. We paused on the last occasion so that we could allow for the celebration of Eid al-Fitr, in particular for the obligations that many members of our community had, and I'm very hopeful that we had a very happy and proper end to the month of Ramadan as our Muslim community and indeed Trinidad and Tobago celebrated it as a whole. Madam President, we were on the last occasion traversing the submissions of honourable senators with respect to this particular bill. And as stated, this particular bill has, of course, caused certain considerations. I had addressed in the short time that I had engaged the wrap-up Senator Mark's allegations that there was no consultation in this legislation and in the process, and indeed I have refuted that by drawing reference to specifically the written submissions coming from Mrs. Elder, Senior Counsel, who's a leading member of the criminal bar and who in fact sat on the committee together with the Chief Justice, the DPP, the Attorney General, Minister of National Security in the consultative process on the criminal justice system. I've put on record that Mrs. Elder's submissions dated the 6th of February 2019 repeated submissions which were given to then Minister of Justice Chrislyn Moore back in 2013. In fact, the letter dated to Minister Moore then was 17th of July 2013. Madam Speaker, it's to be noted that there was a considerable amount of consultation also engaged by then Ministry of Justice in relation to the abolition of preliminary inquiries. I remind as a matter of the record that we engaged in a bill, Act number 20 of 2011, which is the parent law which we are now seeking to do amendments upon. We then went on to the committal proceedings legislation of 2014. And as it stands, there are 3 pieces of law to treat with preliminary inquiries or sufficiency hearings, or the abolition of preliminary inquiries and the adoption of a new procedure. And they are the Preliminary Inquiries Indictable Proceedings Act number 1201 of 1917, number 12 of 1917. They are, of course, this Act number 20 of 2011, and then the Committal Proceedings Act of 2014. It was in the context of that consultation exercise that independent senator, past independent senator, God rest her soul, the very distinguished Dana Sitahal, provided then Attorney General Ram Logan with a detailed set of comments as to what ought to be attended to in the gap between the 2011 bill and the 2014 bill. And in summary, I say, Madam Speaker, Madam President, that coming to this honorable chamber is a continuum of consultative process. And let's put on the record, from 1986 come forward, we have been looking at amendments and indeed the prospect of abolishing preliminary inquiries. And as we stand in 2019 now, the consultative exercise, the comments, the procedures, the acts and omissions that one ought to consider, there's been a plethora of information. So there has been full and proper consideration, and I put that onto the record. Madam President, I was dealing with, when we stopped, with the inconsistency of approach between Senator Hussain and Senator Mark. On the one hand, Senator Hussain took full paternity in fact, I should say maternity of the Act number 20 of 2011, having attributed it to leader of the UNC, Mrs. Prasad Bisesa. And Senator Mark said there was no way on earth that the UNC was going to support this law, this Act number 20 of 2011, essentially because Senator Mark's submission is that the law is somehow unconstitutional. And Senator Mark took a very curious position. In fact, one against his entire government as it then sat, and also bench as it is currently comprised, because when we looked at Act number 20 of 2011, as it was originally passed, and we turn to Section 4, as it was originally passed unanimously, that recommendation of law coming from the UNC in complete voice, here's what it says. Subject to subsection 2, this act shall apply to proceedings which are instituted on or after the coming into force of this act. And here's what subsection 2 says. Where proceedings were instituted prior to the coming into force of this act, the prosecutor or the accused may elect to have the case determined in accordance with this act. Come on, Madam President. Section 4.2, as passed by the UNC government, as that act was partially proclaimed, so ready was the UNC government to implement Act number 20 of 2011 that they brought a note of proclamation to the cabinet, sat on it twice, proclaimed the act, proclaimed Section 34. And today we hear Senator Mark, in a very bold-faced fashion, media actually covering the submission made by Senator Mark. Senator Mark has the temerity to stand before the nation today to say that Section 4 of this act is unconstitutional. I mean, which is it? It was constitutional when the UNC passed it, but it's not constitutional today because the UNC is not in power. Madam Speaker, the intellectual prowess behind that kind of submission leaves a lot to be desired. And I will put it as politely as I can, Madam Speaker. There is an offensive rule in law that you cannot approbate and reprobate at the same time. You can't blow hot and cold. Madam Speaker, Madam President, forgive me, the submission coming further, echoed by Senator Sobers in his reference to case law, and there was merit in some of Senator Sobers' contributions, which I will come to. There was an interesting point which the government agrees should be treated with. But Senator Hussain's reference to the well-known decision of Coriati and in treating with constitutionality has to be addressed. The simple fact is, the rule of law, the requirement of a fair trial, the constitutional parameters set out in sections 4 and 5 are well known to us. But this is not something upon which we need to speculate. This has been answered by the clear dicta of the Privy Council in the Hilroy Humphreys case. Effectively, there is no right to a preliminary inquiry. There is simply a right to a process of a trial. And the reference to the Barbadian law, as given to us by Senator Sobers and others, is of no use. Because in Barbados, they accept the same process that we are engaging in right now. That is, the fairness of trial is to be had in the process of a trial. And in this instance, if there is to be no preliminary inquiry, it is to be dealt with in the sufficiency hearing, initial hearings, as we then proceed to the assizes. Now, Senator Hussain had an interesting submission speaking to the magistrate merely rubber stamping the prosecution, that this amendment, this operationalization of the law should be avoided because in Senator Hussain's submission on the back of Coriati, the case of Coriati, Senator Hussain made the submission that magistrates ought not to be rubber stamps of the prosecution. I must refer Senator Hussain to the supreme law of the Republic of Trinidad and Tobago, so declared by Section 2 of the Constitution. Section 2 of the Constitution clearly identifies the supremacy of the Constitution. And then when you turn to Section 90 of the Constitution, it is in pellucidly clear language that the Director of Public Prosecutions has 3 powers. 1, to initiate prosecutions. 2, to stop prosecutions. And 3, to take over prosecutions. Those are the 3 clear powers. In other words, the DPP can do as the DPP wishes to do, pursuant to the Constitution. It's true that the Preliminary Inquiries Law, Act number 12 of 1917, that law also recognizes that the DPP has a statutory role. If you look to Section 22 of the Preliminary Inquiries Law, the DPP has a role and function. You look to Section 23 in subsections 5 and 8, you will see the DPP also has statutory functions to skip past preliminary inquiries, to reinitiate a prosecution where an accused has been discharged by a court, to also be consulted by a magistrate on a question, as Section 22 of the current law provides. So the submission coming from Senator Hussain that the magistrate is a rubber stamp is respectfully to be ignored in the context of the supreme law, Section 90 of the Constitution. We see as well that Senator Hussain's submission in Clause 4, that the legislative power is interfering with judicial power. It is that same Section 4 that I just referred to, where back in 2011 and in 2012, the then UNC government saw it as no breach of the separation of powers principle, nothing to be frowned upon. That answers the submission that there is something to be feared by way of an intrusion upon judicial power. That is not the case. The law is particularly clear because the issue is not retroactivity per se. It is retrospectivity that is to be frowned upon in the context of the Privy Council's language in the Lianage case. And it is not every act of Parliament which is retroactive or retrospective in effect that falls into odium. You can have perfectly clear laws so stated to be retroactive in fashion, which are upheld as entirely constitutional. We can give an example, for instance, as that argument was considered in the Northern Construction case. The Northern Construction case at the Privy Council and at the Court of Appeal reflected upon the separation of powers argument and the retroactivity argument, and upheld that the repealing law that this Parliament participated in was not one which offended any one of those principles. Now, Madam President, Senator Hussain went on to give a very interesting submission. Senator Hussain said that we have moved away from a prima facie case and we don't know what is sufficient evidence. And he referred us to the case of Galbraith. Madam President, I'm getting more and more concerned with the submissions that are offered by the opposition bench. To make a submission effectively implying that we no longer have security because somehow today in Trinidad and Tobago, nobody knows what is sufficient evidence, because we're now introducing it into law for the first time, is to make a mockery of the law as it has stand in written form since 1917. And let me refer you to this, Madam Speaker, Madam President. Section 23 of the Indictable Offences Preliminary Inquiry Act, Chapter 1201, says this at subsection 2. Where the magistrate is of the opinion on consideration of the evidence and any statement of the accused that there is sufficient evidence to put the accused on trial for any indictable offense, the magistrate shall commit the accused. So, Madam President, where does this understanding that sufficient evidence is some new creature of law, some new standard, and some new parameter of the law really find any merit? that is made false by a mere reading of Act number 12 of 1917, Madam President. And therefore, I really want to urge my learned colleague, Senator Hussain, to focus upon the sobriety of the law. The concept of sufficiency of evidence is well known to our courts. We can rest assured that the courts will continue to assess the evidence on the whole. And in looking at the evidence on the whole, there is comfort to be found in the standard of proof with respect to sufficient evidence, and that is not only the subject of over 100 years of law, but it is the subject of common sense, Madam Speaker. Sorry, forgive me, I'm dancing between houses. Madam President. Madam President, there was reference to a case which was touched upon carefully, and that is a case which featured in the newspapers recently and which dealt with the point of the DPP in the exercise of the DPP's discretion. There was a judicial review application which was brought before the High Court, and the High Court effectively just simply said that the High Court would exercise judicial review in a particular circumstance. It is necessary to touch upon it very carefully, simply to say that that matter is in need of clarification by way of appeal on the law as it stands. The concept of judicially reviewing the DPP is not unknown to us. Indeed, if you were to refer to the well-written text by Dana Sitahal, you will see that back then when the text was published, she contemplated the application of judicial review proceedings on a decision of the Director of Public Prosecutions. But it is material to note that one needs to have care and caution in all of a sudden pouring heavy scorn on the office of the DPP. The DPP's functions and the disclosure of evidence and the criminal proceedings rules require that evidence which is prejudicial to the prosecution's case must be disclosed. And I will say no more than that, other than to say, don't move too quickly upon this. Madam President, we heard coming from Senator Mark, Senator Hussain in particular, a very strong submission, both senators, saying that this law was somehow ad hominem, that this process of abolishing preliminary inquiries is somehow engaged to treat with UNC people alone. That is what was said by my learned colleagues opposite. I wish to, Madam President, reject that submission out of hand. And in rejecting it out of hand, I refer to the very statistics offered in the piloting of this law, where I reflected upon the existence of 33,000 plus cases in preliminary inquiries. 33,000 plus. The fact that one or two members of a political party may be before the courts in serious circumstances is one or two people out of 33,000 existing cases. And I would not be in a hurry to offer an argument that this law is designed to attack a political party. The simple point is to allow a process of trial. I can tell you no, Madam President. Today in Trinidad and Tobago, history was made in the courts. Today, the first plea bargaining hearing under the new legislation was dealt with. That involved a matter of passage of law, movement of the law forward, operationalization of the law, and that impacts the whole realm of preliminary inquiries. Trinidad and Tobago therefore witnessed today that this Senate passed the plea bargaining legislation. This government proclaimed the law. This judiciary saw the movement of a file from the Magistrates' Court to the High Court in one day. This judiciary had the first ever plea bargaining hearing in the history of timeliness engaged in. And the fact is that a trial of that matter has been set for January 2020. So, Madam President, I'm giving you an example of how a law can be operationalized, of how the little elemental pieces of what we are doing, public defenders, criminal proceedings rules, implementation of a system of masters, plea bargaining on the back of bail management, etc. This 11th Republican Parliament is making history in passing law and operationalizing it for the first time. Madam President, there was an interesting question about bottlenecking raised by Senator Hussain, joined by Senator Thompson-Aye, and there was a legitimate argument raised by my learned colleagues as to whether the elimination of magistrates conducting preliminary inquiries is simply to take the bulk of matters that are at the magistrates' court and just drop them at the doorstep of the High Court. That's a very legitimate concern. Senator Sheikh also brought very commendable argument into the considerations for operationalization. I think the Honourable Senator gave good contribution on that measure, and I think that the submissions need to be answered. The fact is that the judiciary must obviously operate in a system. There must be people, there must be posts, there must be financing, there needs to be buildings and structures. And senators opposite on the UNC bench, on the opposition bench, quite properly pointed to the state and condition of the magistracy, the courts at Princestown, at Rio Claro, at Siparia. Senator Choate gave us a very vivid example of how the list is managed in the Rio Claro courts, and where effectively between 9 and 10:45 the matters have to be dealt with. And Madam President, what I can tell you is, it was for that reason that this Senate passed, together with the House, the criminal division, if I call it in its short form. And in operationalizing the criminal division came the amplification of the number of masters. And when we did the family and children division, and we did a miscellaneous provisions position, we raised, as Senator Prescott will well remember, we raised the number of judges, the qualifications, from which jurisdictions they may come. We have effectively seen a 77% increase in judicial capacity on paper. The judiciary has closed off the application receipt for judges of the High Court. I understand that several posts for judges will be filled as a result of the JLSC's exercise, which is ongoing now. The magistrates are being trained and tutored. The Judicial Education Institute under Madam Justice Gillian Lucky is hard at work. The masters of court are receiving training and management, and indeed the legal profession, via the law association's engagement of training, is also busy at work. But Madam Speaker, Madam President, when I listen to my learned colleagues opposite speak, and indeed if I were to reflect upon the many contributions coming from Senator Mark, yet again, on motions on the adjournment and questions on the Parliament, the advocacy coming from the opposition is that somehow, and Senator Hussain said this quite vividly, people in the judiciary, employees of the judiciary, are left crying. Senator Hussain went so far as to say they tried it in respect of crime and they failed, and now they're trying to deal with the criminal justice system. Madam President, for the record, there is a systemized engagement with the judiciary staff in the 13 district criminal and traffic courts and 3 criminal division locations, the implementation of the 12 units, each unit being staffed and populated by divisional judiciary secretaries, judicial support officers, associate judicial support officers, judicial orderlies, judicial research counsel, 5 in number for each of them. That is 25 support officers being put into the background to work alongside the judicial officers themselves, masters, registrars, judges. That is how you make the system begin to happen, to move in the fashion that you saw in the plea hearing, which we made history on as a country today. Madam President, that is to be supplemented by new units in the criminal division, witness support unit, bail management unit. There is, in fact, an improvement in the number of positions which are being managed. And Madam President, let me put that onto the record. As a cabinet, our government has in fact approved a very significant improvement in the judicial structures. We have approved, and the judiciary is actively afoot being funded, in the creation on contract of 217 new positions. That is being done right now. Yes, of course, contract. The contract positions being lawfully permitted under the Family and Children Division and also under the Criminal Division, but permanent and pensionable positions are to be backed by the provision of funding for pensions. I hear the UNC speaking now very glibly about contract positions when the UNC as a government prospered on contract provisions. And more than that, after breaking the treasury to ensure that there was nothing left in it by way of monies to pay for permanent and pensionable positions, all of a sudden today, the UNC bench is surprised about the utilization of contracts. You cannot have permanent and pensionable positions if you can't pay for it. And therefore, the utilization of contract positions in the same vein that was utilized by the UNC government shouldn't be new information to the UNC bench. Further to the 217 positions, Madam President, I'm pleased to say that there are further 84 positions. We are using 64 contract positions for transcriptionists. We are going to look at the improvement of 68 positions for permanent and pensionable offices. We're redeploying 22 vacant permanent pensionable offices and then further absorbing. Madam President, we have created the Human Resource Management Unit, Finance and Accounts Unit, Fines and Fees Unit, Records Management Unit, Court Reporting Unit, Statistical and Evaluation Unit, Drug Treatment Court Unit, Criminal Court Information, Communications Technology Unit, Witness Support Unit, Bail Management Unit, Court Office Unit. These have not happened by mistake. There was a dedicated creation of operational bodies into positions, under structures, underwritten by the Minister of Finance to operate these laws. And that is why we are confident that the bottleneck argument can be managed. But Madam President, that bottleneck argument is to be managed only if you encourage more and more trials to settle. Let me put it in a very simple way. How does a trial not happen? Number one, you clean up the list. Either witnesses are present or not, matters are not capable of moving ahead or not, or you encourage plea bargaining, the use of MSI, maximum sentence indication positions. You encourage those things so that you will encourage people to avoid a trial by going through a judicial process, which is a plea bargain and a plea hearing. In other words, quite simply put, the first guy on the bus gets the best seat. And people understand that best seat concept as it is. That is a terminology coming from the United States of America. The first guy on the bus gets the best seat because the weight of prosecution evidence is more certain. So they rather plea bargain than face the wrath of a court where evidence is secured. And Madam President, that's where the Commissioner of Police is to be commended. Because it is under this Commissioner of Police that an entirely new prosecutorial unit in the Trinidad and Tobago Police Service has been birthed to manage serious fraud, complex crime, money laundering, and other matters. That involves the imposition and implementation, which is actively on deck right now, of specialist attorneys from the United Kingdom, forensic auditors, forensic accountants. There are 32 forensic auditors and accountants that come from one division alone, and a further 6. This kind of prosecutorial weight, Madam President, has never before been institutionalized in Trinidad and Tobago. And that is why in Act number 20 of 2011, when we as a Senate amended it in February, we specifically included in the definition of a prosecutor the fact that the Trinidad and Tobago Police could prosecute. Because the Trinidad and Tobago Police is no longer coming with a policeman as a prosecutor. They are coming with specialist prosecutors coming from the United Kingdom, coming from Trinidad and Tobago, who are right here in the country working right now They enter the domain as special reserve police. Do you understand what I am saying? The game has changed. The population may not understand that just yet, but I think the UNC understands it when I hear the submissions coming from them. And I want to dissuade them from pouring fright into the population. If I stood as someone against whom an allegation was made, I would think it fortuitous to want to get to a trial which will exculpate me, rather than languish in 20 years of preliminary inquiry to eventually get to a trial at the assizes. This prospect of improving prosecutorial march is what is required in this country. It is only when that happens that there is a fear that if you do the crime, that you must do the time. It is to make a mockery of common sense if the time never factors, Madam President. Madam President, Senator Hussain and several others, Senator Sheikh, also chimed in on this particular purpose, albeit in a different dimension, speaking about the buildings and court units. I can tell you today that San Fernando Magistrates Court is to be constructed at Irving Park, just on the corner next to Afan's Bakery. There was land that was purchased there by then Attorney General Anand Ram Logan to build an office of the Attorney General. There's no need for that office. We took that land and we vested it in the judiciary, and they are busy afoot now in the construction preparations. Secondly, Madam President, we also took note of the fact that 2 other buildings were purchased under the UNC in San Fernando, neither of which can be occupied, because the Ministry of Works is on record in saying that those buildings are unfit for purpose. So when the UNC comes today to tell the country we're going in a court and a shift system and it's junior sec and senior sec, you put us there. Not a single building was repaired. Not a single promise fulfilled in the creation of judicial complexes. Nothing was done. And today we have to hear the opposition tell us about where are the courts, Madam President. Madam President, Senator Mark says blame. No, we're not blaming, we're doing. We have vested today the Siparia post office for the retrofit by the judiciary for creation of a court there. We are treating with the creation of the courts at the remand court unit at the Golden Grove site, where you will no longer have to leave the prison, you can appear from the prison. But that is entirely contingent upon the Senate, because the ability to appear by video conference feed is the subject of another bill, and when we get back to that, we will treat with what the UNC's position is on that. Madam President, we note that there was a submission coming from Senator Choate as it related to a few provisions. Senator Sobers also raised the issue of Clause 5. We saw in the submission coming forward from Senator Sobers, a very important submission came from him. Senator Sobers asked us to have a look at an approach to be taken with respect to Section 4. Senator Sobers then went on to ask us whether we ought to define what is complex and serious fraud. I just want to refer Senator Sobers to the specific language of Section 23, subclause 8 of Act number 12 of 2017, where the exact terminology is used, where you can have no preliminary inquiry pursuant to the DPP's election, and that has been the law for a very long time. We hang our hat legislatively and in terms of interpretation of laws squarely upon the existing law. Senator Sobers asked us to look at Clause 5, and in particular the proposed Section 6.3d. The Honourable Senator suggested that the evidence should be filed before the court, since it could be a master or magistrate. I thank the Honourable Senator for that observation. He has hit the nail on the head. The government believes that that ought to find itself by way of an amendment before the House. I thank you, Senator Sobers, for that particular submission. We believe that we should amend it so that the determination is made by the DPP, as it does not involve filing of evidence before the court. So we will circulate an amendment to that. Senator Choate's submission in relation to Clause 4 and the hollowing out of the law, as Senator Choate put it, and the fact that the law, and forgive me if, Senator, I've put it in my own words and not in the words that you have used, effectively that the law is there for individual management and not necessarily for the group, as I recorded the submission. In looking at that particular submission, I would just simply say that we perhaps have run into a slight disagreement as to whether we ought to have the joint trial and joint charge approach. The fact is that without the joint trial or joint charge approach, then the law is silent on it. And then we would be inviting confusion into the marketplace, being the court.
Attorney General, you have 5 more minutes.
Yes, Madam President. We'd be inviting confusion into that particular aspect. In fact, Mrs. Elder, senior counsel, took the exact opposite point of view to Senator Choate. It was Mrs. Elder that really impressed upon us, as we found in the learnings coming, in the recommendations coming from Dana Sita-Hall in her 2014 written submissions. They both centered upon the fact of the need to treat with joint trial and joint charges in the very fashion that we have proposed now before the Honorable Senate. Madam President, the position with respect to Section 6E and the issue of child charge, Senator Choate made a very important observation about a child charged not being factored in the circumstances where the DPP may wish to avoid a particular preliminary inquiry. I thank Senator Choate for that submission. We propose that we cause an amendment to be made in that regard. We were also asked to be mindful of the discretion to exclude certain types of evidence, effectively the argument that shall ought to be made, and this is in the context of Section 29(6), as we propose it is amended. I think Senator Choate is right that we ought to preserve the court's discretion to consider the admissibility of evidence, and therefore we agree with that submission, Madam Speaker, Madam President. With respect to 32A52B and whether parties to proceedings should have a right to agree to having a date, we just wish to put on the record that we have sought to keep it in harmony with the manner in which you may vary a timetable by consent, which is something that we have in the civil proceedings rules, where the parties can, with the permission of the court, vary a timetable by consent, and that is the back for why we had proposed 32A in the fashion that we have. Again, this is subject to judicial discretion and is not unknown to us in a rules-based environment. Madam President, Senator Ahi was right. Senator Ahi reflected upon an anachronistic colonial long walk to freedom. And it reminded me to go back and take a look at what Lord Devlin had to say in 1960, that preliminary inquiries are an ossified form of regulation which we labor under. So whether it is anachronistic or it is an ossified form of labor under which we toil, we have difficulties, we agree that it is time for this law to be done. Senator Prescott's last submission as I come, Senator Prescott's urgings to have a look at the law post the Domestic Violence Act. There are 2 aspects to that. Under the Domestic Violence Act, of course, the jurisdiction is summary, and it is a summary matter, not an indictable matter. However, the Domestic Violence Act does make reference to certain indictable matters where charges can be brought under that realm. We think that the 2 can be separated out. And we did go back and have a look at the law post the Domestic Violence Act. In looking at Section 6.3, in the fashion that Senator Mark suggested, we thought that we could keep it because it was in keeping with the existing provisions in Section 23.8 of the existing Preliminary Inquiries Act, Chapter 1201. Madam President, I will ask that our submissions for recommendations be circulated by the CPC's division. We welcome the submissions that honourable senators may have to make in respect of this law, and we can have a more fulsome discussion in committee stage. I'm grateful that honourable senators who were present on the last day are in fact still all together present on this day, and I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be now read a second time. Those in favour say aye. Aye. Those against say no. The ayes have it.
An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that a bill entitled An Act to Amend the Administration of Justice Indictable Proceedings Act 2011, Act number 20 of 2011, be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Aye. Those against say no. The ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. To you, General. Honorable Senators, we are in receipt of amendments from the Attorney General, which will be circulated, but we also just received amendments proposed by Senator Mark, which we now have to copy and circulate. So I'm going to suspend the committee for 15 minutes so that everyone can then have their documents in order. So the committee is suspended for 15 minutes.